1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်1142ဦးကျောက်စိန် applicant versus the additional commissioner of income tax Burma respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Miscellaneous Application before ဒေါက်တာမောင်မောင် Chief Judge and ဦးချစ် Judge ဦးကျောက်စိန် Applicant versus the Additional Commissioner of Income Tax Burma Respondent Burma Income Tax Act Section 66 to the best of judgment assessment income of the assessee from undisclosed sources construction of the president cinema reliance on valuation of assessors and other reports in making the assessment whether it can be said the assessment were made perversely or in the absence of evidence estimated income used in the construction for that year itself Burma Income Tax Act Section 37 Burden of Proof the applicant applying to the appellate tribunal to refer to this code the question as to whether the tribunal was justified in law in holding that the best of judgment assessment for each of the 4 years constituted the income of the assessee from undisclosed sources liable to assessment in that year. The tribunal decided that there were no questions of law for reference to this code, but only findings of pure fact. Hell, until she started building the President Cinema, .ag annual incomes were not of accessible proportions. Thus, the huge construction began from funds for which she assumed sole responsibility, but whose sources she could neither account for nor explain. After 4 years or more of waiting for her to submit her accounts, the income tax officer proceeded to make his best of judgment assessment on the basis of the cost of construction estimated for each year. He had the valuation of assessor and other reports in making the assessment, and it cannot be said that he had made them perversely or in the absence of evidence. He did not hold that the assessee income, which he estimated for one assessment year, was not available for investment in the next. What he decided was that the estimated income was used in the construction for that year itself. This method of assessment was inevitable in the circumstances. Held further, it was not for the income tax officer, the assistant commissioner, appellate, and the appellate tribunal to take evidence to verify if .ag admittedly belated explanations of indebtedness were true under Section 37 of the Burma Income Tax Act. When the burden was on .ag and when she had enough time and opportunity to discharge it, no question of law arises and therefore the applications are dismissed. Upai for the applicant, Ubajo, Assistant Attorney General for the respondent, Dr. Maumau, Chief Judge. These 6 applications arise out of similar circumstances concerning the same assessee and since they pose identical questions of principle, we have had them together on the motion of Learned Counsel. This order disposed of all the 6 applications. AG, the proprietress of the President Cinema, was called upon to submit her accounts and returns for the 4 assessment years, 1955 to 1956, 1956 to 1957, 1957 to 1958, and 1958 to 1959. On her failure to respond promptly and satisfactorily, the income tax officer proceeded under Section 23(4) of the Income Tax Act to make best of judgment assessment. He also taxed her for business profits for each of those 4 years. The assessee invoked Section 27 of the Act to try and get the assessment cancelled, but without success. Her first appeals to the Assistant Commissioner of Income Tax Appellate were not of any significant success, for she only won small reductions in her quantum appeals. The second appeals, which she preferred to the appellate tribunal, went through a rehearing after a reference was made to this court and were finally dismissed. In the course of the series of appeals and references, AG died and her husband, Wu has pursued her cause as her legal representative. Wu applying to the appellate tribunal under Section 66(1) to refer to this court the question as to whether the tribunal was justified in law in holding that the best of judgment assessment for each of the 4 years constituted the income of the assessee from undisclosed sources liable to assessment in that year. The tribunal, after hearing counsel, decided that there were no question of law for reference to this code, but only findings of pure fact. His quest with the tribunal having failed, Wu has come and placed the questions before us, asking that we find them to be questions of law and fit for a direction to that effect from us to the appellate tribunal under Section 66(2). Wu Bai, land counsel for the applicant, relies heavily on the ruling in Swami Mudalia vs. Commissioner of Income Tax 1 that once the income of an assessee had been assessed on an estimate basis, the estimated income must be treated as the real income, and if the assessee claimed that the investment he made in subsequent years came out of the income, his claim should not be rejected on the ground that the estimated income was merely intangible or imaginary. It would not be open to the authorities to take the view that the estimate was made only for taxation purposes but had no relation to the true income of the assessee. That would only be fair and just, for if an assessee had to pay tax on an estimated income, but was denied the opportunity to explain that he made subsequent investment from that income, it would amount to making the assessee bear the burden without the opportunity to reap due benefits. The argument advanced by Wu Bai seemed to be that as large sum of money were assessed to income tax against AG for 4 successive years from 1955 to 1956 on a best of judgment basis, she should have been allowed to explain that she was able to meet the cost of constructing the President's cinema. In each succeeding year from the income that the authorities had estimated to be higher in the previous year, the estimated income for 1 year would, in other words, cover at least partially the cost of construction in the following year, and the cost therefore should not have been put down by the authorities entirely on undisclosed sources of income for that subsequent year. We fail to find, however, that .ag give this explanation to the income tax authorities. All she did, it seemed, was take time after time to produce her books, and finally she explained that she had borrowed from banks, funds, and individuals. Called upon to furnish proof and detail of her indebtedness, she again failed to do so in the time given her. Ubajo, the learned assistant attorney general, submits that the income tax authorities had the President's cinema value by qualified engineers and assessors, buildings, furnishing, equipment, and all, and allocated and separated out the total estimated cost over the assessment years in question. Then, costs for each year will held to be the income of the assessee from undisclosed sources, as estimated income for each of the 4 years was deemed to have been utilized in the construction of the cinema for that very year. There was no question of the income being available for investment in the following year. We consider that in the circumstances of these cases, U's line of reasoning cannot hold until she started building the President's cinema. .ag annual incomes were not of accessible proportions. Thus, the huge construction began from funds for which she assumed sole responsibility, but whose sources she could neither account for nor explain. After 4 years or more of waiting for her to submit her accounts, the income tax officer proceeded to make his best of judgment assessment on the basis of the cost of construction estimated for each year. He had the valuation of assessor and other reports in making the assessment, and it cannot be said that he had made them purposely or in the absence of evidence. He did not hold that the assessee income, which he estimated for one assessment year, was not available for investment in the next. What he decided was that the estimated income was used in the construction for that year itself. This method of assessment was inevitable in the circumstances. Next, Ubai argues that the income tax officer, the assistant commissioner appellate, and the appellate tribunal could have, under Section 37, taken evidence to verify if .ag admittedly belated explanations of indebtedness were true, but the burden was on .ag and she had enough time and opportunity to discharge it. The appellate authorities considered her appeals carefully and came to the same conclusions of fact. We concur with the appellate tribunal that no question of law arises for reference to this code. We cannot go over the facts again as if we were a third court of appeal. Our power under Section 66 is limited, and we must neither abdicate that power nor extend it. The applications are dismissed with one set of costs, advocate fee, debt $340,